Hello, everyone. I'm Gustavo Almaceda Hoyos, a lawyer and a doctor in criminal law, and I warmly welcome you to my channel. Today, we're going to tackle a topic that's redefining the fundamental paradigms of law and criminal law, the convergence between artificial intelligence and criminal law. I want to remind you that every week I publish videos on legal topics, analysis of landmark cases, jurisprudence, compliance, and geopolitics. This space is designed not just for lawyers, law students, and professionals, but also for anyone interested in better understanding the legal reality and the geopolitics that surround us. My purpose with this channel is to share knowledge, promote debate, especially academic debate, and address the most common concerns we see in the legal field. So if you're interested in staying informed with a serious and well-documented approach, I invite you to subscribe and turn on notifications so you don't miss any of our upcoming videos. Let's get to the point. The technological revolution we're experiencing is not only transforming legal practice, but it's also questioning the very foundations of criminal law. Oops, I got a little carried away, sorry. Artificial intelligence, used with its autonomous processing and decision-making capabilities, raises questions that transcend traditional legal frameworks. Let's move from the general to the specific. Let's start with what the conceptual framework is and its evolution. Artificial intelligence, in its most basic conception, represents, let's say, computational systems capable of emulating human cognitive processes. Its implementation in the criminal field raises fundamental questions regarding the principles of culpability, causality, and criminal responsibility itself. Chile has developed, both directly and indirectly, a regulatory framework that includes various laws regarding this matter. Let's mention the law. The numbers don't really matter, but for the sake of order, I want to point them out. Law 21719 on personal data protection, which establishes fundamental guarantees against the automated processing of data and decisions based on artificial intelligence. I say directly and indirectly. I want to emphasize that Law 21663 on cybersecurity and the protection of critical infrastructures. I really struggle with that word. For those who have seen other videos on the channel, infrastructure. I'm going to go over everything every morning in front of the mirror. Infrastructure. All right. Law 21459 on cybercrimes, and Law 21595 on economic crimes. This regulatory ecosystem reflects the complexity of regulating the intersection between technology and criminal law. Law 21719 is particularly significant as it sets specific limits on the automated processing of personal data in criminal investigations, establishes safeguards against the creation of criminal profiles, holds individuals criminally responsible for the improper handling of sensitive data, and provides procedural guarantees against automated decisions that affect fundamental rights. Moving on to the topic, what are the emerging issues? Now, diving into the regulatory framework for protection. Chile has developed a robust, let's say, regulatory system to tackle the challenges of the digital age, or at least to try to tackle the challenges of the digital age. Law 21663 on cybersecurity establishes a fundamental framework, as we said, for the protection of critical infrastructures, complementing Law 21459 on computer crimes and Law 21595 on economic crimes. This legal framework configures a multi-level protection system that must constantly adapt to new threats enhanced by artificial intelligence. The designation of critical infrastructures and the cybersecurity obligations established by Law 21663 are particularly relevant when we consider the potential of artificial intelligence to autonomously identify and exploit vulnerabilities, to execute large-scale coordinated attacks, to compromise critical systems through machine learning techniques, and to evade traditional protection mechanisms. Now, getting into the issue of determining criminal responsibility. In cases involving artificial intelligence systems, this presents unprecedented challenges. Here, several questions come to mind. For example, how do we apply the principle of culpability when decisions are made by algorithms? First question. Another question is, who is held criminally responsible? The developer, the user, or the entity that implements the system? Well, here we get into the topic of evidence, digital evidence, and due process. The developer, the user, or the entity that implements the system. Well, here we get into the topic of evidence, digital evidence, and due process. The use of evidence generated by artificial intelligence in criminal proceedings introduces new variables in the evaluation of evidence. The reliability of algorithmic systems and the potential for biases in their programming require rigorous scrutiny to ensure due process. And now, moving into the geopolitical dimension, the regulation of artificial intelligence can't be analyzed in isolation from the global geopolitical context. Tensions between technological powers, such as the US and China, are shaping the development of international regulatory frameworks, with direct repercussions on the legal system, national issues, and this is where we get into the specific challenges. Specifically regarding algorithmic biases, artificial intelligence systems can perpetuate and amplify pre-existing social biases. In the criminal field, this is particularly concerning when these systems are used for assessing the risk of reoffending, determining precautionary measures, or for predictive crime analysis. And here, moving forward and trying to be systematic in the analysis, we enter into advanced cybercrime and economic crimes. The intersection between artificial intelligence and crime is creating new challenges for the criminal justice system. The recent Law 21595 of 2023, which modernizes economic crimes, is particularly relevant when facing new criminal modalities enhanced by artificial intelligence, such as, for example, automated manipulation of financial markets through algorithms, what are known as deepfakes in extortion and corporate fraud, automated attacks on critical economic infrastructure systems, mass manipulation of information to make financial decisions, and the so-called Ponzi schemes and automated pyramid scams through what are known as smart contracts. This legislation, together with Law 21459 on computer crimes, establishes a regulatory framework that seeks to adapt to the growing technological sophistication of economic crime. However, the speed of innovation in artificial intelligence presents constant challenges to its effective application. And what recommendations, what proposals can we make? Regarding the regulatory framework, it's imperative to keep developing and updating our legislation, building on the advancements of the laws we've mentioned, to establish clear criteria for criminal liability in cases involving artificial intelligence, especially in complex economic crimes. We need to define standards for algorithmic transparency in financial and corporate systems to ensure the protection of fundamental rights. Amid automated decision-making, we should also develop specific mechanisms for prosecuting economic crimes facilitated by artificial intelligence, and implement cooperation protocols between financial entities and prosecutorial bodies for the early detection of automated criminal patterns. And there's a topic we haven't addressed, which is international cooperation. The transnational nature of these challenges necessarily demands a coordinated response. The cybersecurity law, by aligning Chile with international standards on the subject, facilitates international regulatory harmonization regarding the protection of critical infrastructures, cooperation protocols in criminal investigations and incident response, common standards for digital due process, the exchange of information on emerging threats based on artificial intelligence, coordination in responding to incidents affecting interconnected critical infrastructures, and the development of joint capabilities for detecting and neutralizing automated threats. And finally, to conclude, criminal law is at a historic turning point. The integration of artificial intelligence challenges us to rethink our discipline. Legal professionals must ensure this evolution respects criminal law principles and human rights. As legal professionals, we have the responsibility to ensure that this technological evolution does not compromise the fundamental principles of criminal law, nor the protection of human rights. I invite you to dive deeper into this crucial topic. In future episodes, we will address aspects like digital evidence, algorithmic accountability, and emerging new types of crimes. Your comments and perspectives will enrich this essential debate for the future of our discipline. Please leave comments on topics you would like me to cover in future videos. Thank you very much for sticking with me until the end of this analysis. If you like this content, please give it a thumbs up and share it with your friends, colleagues, or anyone interested in these topics. Don't forget to subscribe to stay updated with the weekly videos on legal topics, analysis of landmark cases, jurisprudence, compliance, and geopolitics. Your participation is very important to create a space for debate and mutual learning. Leave me your questions, leave me your comments, and I'll be happy to review them in upcoming videos. See you soon.